Mr. President,
Senator from Wisconsin.
I rise to speak to an amendment I filed on House Joint Resolution 59, the continuing resolution. It's a pretty simple amendment. It simply prohibits that funds be used for a government contribution for the health insurance of members of Congress and staffs under Obamacare. Now, you might ask, well, why would I, as a former employer, want to prevent an employer from contributing to health plans for members of Congress and their staffs? Well, it's a simple reason is because of the passage of Obamacare, it expressly prohibited funds from being contributed by the federal government to members of Congress and their staff's health care plan. I do not believe the President has any legal authority, and I certainly do not believe the Office of Personnel Management has the authority to circumvent the Affordable Health Care Act. Now, I am exactly on board with Senator Moran in certainly wishing that we could repeal the health care law in its entirety, that we could defund it, that we could do anything we could to limit the damage. But the fact of the matter, it is the law of the land, and we need to respect the law of the land. And as I've looked through the legislative history of the passage of the Patient Protection and Affordable Care Act, it seems very clear of what the intent of Congress was. Back on September 29, 2009, as this was being debated in the Senate Finance Committee, Senator Grassley offered an amendment that was adopted without objection that would require members of Congress and their staffs to, I quote, use their employer contribution to purchase coverage through a state-based exchange rather than using the traditional selection of plans offered through the Federal Employees Health Benefit Plan. Again, that amendment was adopted without objection. Apparently, members of Congress at that point in time thought that the state-based exchanges were going to offer such fabulous health care that they wanted to make sure that members of Congress and their staff could avail themselves of that opportunity. So on October 19, 2009, that Grassley provision was incorporated into the Finance Committee's Americans Healthy Future Act. But there was an addition to that amendment made that basically provided for an employer contribution. It says, Section B-II says the employer contribution may be made directly to an exchange for the payment of an offerer. So at that point in time, it was express will of Congress that the employer, the federal government, could actually contribute to the health care plan purchased through the exchange. The problem arises, however, that when Senator Reid actually offered the language for the Patient Protection and Affordable Care Act on November 18, 2009, it specifically said that only health care plans that the federal government may make available to members of Congress and congressional staff with respect to their service as a member of Congress or congressional staff shall be health plans that are, 1, created under this act or an amendment made by this act, or 2, offered through an exchange established under this act or an amendment made by this act. There was absolutely no provision made whatsoever for an employer contribution to those health care plans. On December 24, 2009, Christmas Eve, the Senate passed that bill without any language making no provision for an employer contribution to those plans purchased through an exchange. It was passed on pure party lines, 60-40. On March 21, 2010, the House passed the exact same legislation. But then there was a debate in terms of reconciliation, and Senator Grassley once again offered an amendment that would have provided an employer contribution to those plans purchased through the exchange. It was explicitly stated that that employer contribution could be made, but that amendment was voted down. It was voted down by a vote of 56-43. All but 3 Democrat senators voted no. And in the end, the health care law was passed. That reconciliation was passed on March 25, 2010. Now, what happened recently, on July 31st, 2013, President Obama came over here to the Hill and met with Democratic senators because, as Nancy Pelosi famously stated, that we have to pass this health care law before we can figure out what's in it, before we know what's in it. Well, once senators found out what was in it, that they're going to have to purchase their health care through an exchange and that the federal government could not make any payment for those health care plans, they panicked. And they asked President Obama to please correct that. And so President Obama heard their plea and directed his Office of Personnel Management to propose a rule that would allow the federal government to pay or make a contribution to those state-based exchange plans. Now, I would argue that the OPM, President Obama, has no legal authority whatsoever to make those contributions, which is the purpose of my amendment. There will be millions of Americans that will lose their employer-sponsored care for various reasons, but because of the passage of the health care law. Once they've lost that coverage, every other American will have to purchase insurance either on the open market or through a state-based or federal exchange. Their employers will be barred. They will not have the opportunity to make an employer contribution to help pay for those health care plans. The only way a normal American gets to have any subsidy in those exchanges is if their income qualifies them for a subsidy under the Affordable Health Care Act. The only Americans that now, because of this OPM ruling, they will actually have their employer be able to make a contribution are members of Congress and their staff. That is simply wrong. That is special treatment. It really should not stand. So my amendment basically acknowledges that this is the law of the land, that President Obama, that the Office of Personnel Management has no legal authority to make that contribution, and so it simply prohibits funds to be used for a government contribution for the health insurance of members of Congress and their staffs under Obamacare should be prohibited. With that, I yield the floor.
Mr. President.
Senator from Georgia.
Mr. President, I rise today to discuss the House-passed continuing resolution now pending before the Senate. Once again, the Senate is considering a last-minute continuing resolution rather than regular order appropriation bills. Handling the annual appropriation bills process in this way is a bad deal for the American people, and it's a deal that we have gone through for the last 4 years now without passing appropriation bills and having to deal with a continuing resolution or an omnibus, which is simply a terrible way to run this government. Congress should be passing appropriation bills in regular order instead of waiting until the 11th hour, and I know the chairman of the appropriations bill and the ranking member are very much in favor of doing that and are ready to come to the floor to do that. But yet, once again, we're seeing the majority leader not let them come to the floor with those bills. This only creates uncertainty in the financial market and hampers America's economic recovery. Unless we come to an agreement, the government's going to shut down Monday night because Congress failed to pass a bill that would fund the government for only a few months. And to what end?